Right, morning everybody, and thank you for waiting, and welcome again to the webinar. I'm going to be presenting this morning with Charlotte Fleck.
Hi everyone.
Talking about employee shareholder status, current thinking and practice. We expect to be talking for 30-40 minutes or so. If anybody has questions, I think the easiest way would probably be to email those questions in either during the course of the webinar or when we're finished, and we'll be happy to come back and respond to those. So just to give some background, and I appreciate that many people will know the background, but it's probably helpful to remind everybody of the context. Employee shareholder status, sometimes known as shares for rights, was introduced in 2013, and the stated objective was to encourage recruitment by smaller businesses. So the economic thinking behind the introduction of the relief was that smaller businesses sometimes are reluctant to recruit, it was thought, due to the statutory employment rights, in particular unfair dismissal and redundancy rights applicable for all companies, and the economic thinking was that lots of small businesses indicated that they were reluctant to recruit people because of the potential cost of redundancies, unfair dismissal, etc. So the theory behind that was that there was a relatively limited relief introduced for the value of shares given up front, with tax protection on the initial value of up to £2,000 and capital gains tax relief on the sale of shares with an initial value of up to £50,000. The focus in the discussions at the time was more on the initial tax relief, the £2,000 relief, rather than the CGT. For the reasons that we'll come on to, it's probably the case that the CGT relief is proving to be more significant than the income tax relief. The introduction of ESS was politically controversial. What we saw as we were coming up to the last election is that all the major political parties, other than the Conservatives, were committed to abolishing the relief. There were difficulties when the legislation was introduced with securing the passage of the bill through the House of Lords, and that is actually evidenced by the need for independent advice. The background to that was that the requirement to obtain independent advice did not feature as part of the original legislation, and was introduced quite late in the day in order to encourage the Lords to allow the legislation to pass and the relief to be introduced. The question, though, is what's happening with ESS in practice. My expectation, and I think that of many practitioners when the relief was introduced, was that it would not be widely used. And the reason for that is that if you look at the plain vanilla ordinary shares, which I think it had been assumed would be used for the purposes of ESS, why would somebody give up potentially valuable employment rights in return for something with an initial value of £2,000? And the answer is probably not very many people. What we have seen in practice, though, is that ESS is not widely used in the circumstances envisaged by the Chancellor, but is more focused on senior executives, including private equity companies and the companies which they invest in. We have seen frequently ESS being linked with growth shares. So growth shares are, broadly speaking, shares which participate in value above a certain threshold. And the point with those, which is relevant to the ESS relief, is that what that then creates is a form of share which has a very low value, potentially at least a very low value, but equally with potential for large gains according to the performance of the business. And this is particularly pertinent when we look at PE-backed houses. What you're therefore looking at is shares with very low initial value, may well be no more than the £2,000. The £2,000 is the minimum value that's required for the shares to attract the ESS relief. May well be worth no more than that £2,000, but with potential for very large gains over time. And I think if you step back and think about the context of the way that private equity transactions work, very, very broadly speaking, people tend either to make nothing out of them or very large numbers. And what this relief does is to create the prospect of the very large numbers being received completely free of tax. Now, I think that is partially explains why there have been a relatively large number of ESS arrangements introduced relative to what we would have expected. But I think it also means that there's a risk of future changes of law to limit or to remove the relief. I think what is also the case is that I personally perceive a risk as time goes by that when it becomes apparent that such large numbers are being tax protected, that HMRC, who to date have been relatively sanguine about the reliefs offered by the ESS, will become much more concerned and therefore review the detail of the legislation, how it's been used, whether there are any weaknesses much more fully. And as we will see as we go through and talk about the detail of the way that ESS operates and the requirements, the legislation is not necessarily well drafted. What that does is to create areas of uncertainty, and areas of uncertainty are where HMRC might focus and challenge arrangements which have been introduced. So we're going to talk about some of those points in more detail, at which point I'll hand over to Charlotte.
Thanks, Stephen. So I'm just going to skim through the basic requirements for an award of employee shareholder shares. As Stephen said, the principles are fairly straightforward. The employee gets issued fully paid new shares worth at least £2,000, and in exchange the employee gives up their employment rights. Employees treated as paying £2,000, so that value is exempt from income tax and NICs. Minor point that £2,000 is included though in the corporation tax deduction that the company gets, although £2,000 worth of corporation tax relief is often not a huge consideration for the sort of companies that are making the awards. Then as long as the shares when they're awarded are worth no more than £50,000, which they generally are not, then the entire gain on value of the shares going forwards will be completely exempt from capital gains tax up until the time there's a disposal. That can obviously be very valuable indeed, especially when, as Stephen said, it's linked with growth shares, so there's low initial value but potentially very high gains. So this obviously can be significantly more advantageous than one of the other common approved schemes, EMI, where the gain in value, which is broadly analogous, but the gain in value is subject to tax, albeit at the 10% entrepreneurs relief rate. So what are the employment rights that are given up? As far as I'm aware, this is not a very scientific selection. This is just the employment rights that the EU permits to be given up, rather than the employment rights that have been specifically selected as appropriate. So the employee gives up their right to make a claim for unfair dismissal, but not the right to make a claim for discrimination or for having been unfairly dismissed on health and safety grounds. And I will note there's a new unfair dismissal right, which is that if you were dismissed because you refused to accept your employer's offer to become an employee shareholder, you will be considered to be unfairly dismissed. You also give up your right to statutory redundancy pay, so those are really the key ones, but you also give up various minor rights to request flexible working, request study leave or training, and you have to give additional notice when coming back from parental leave. One important point is that the only consideration the employee can provide is giving up their employment rights. So what is consideration here? It's pretty rare to have an employee shareholder agreement that simply says, here are the rights you're giving up and here are the shares you're getting. For example, especially with growth shares, it's normal to have a Section 431 election. What that does is ensure that the entire initial value of the shares will be taxed to income tax at the outset, which means that the rest is into capital gains going forward. So the rest for employee shareholder shares should be tax exempt. So is the employee giving consideration by agreeing to enter into a Section 431 election? I don't know of any companies that would be altogether happy to make a share award without asking the employee to enter into one, but it's certainly not clear from the text of the employee shareholder legislation whether this is actually consideration or not. Similarly, normally the employee is going to agree to make good their tax liabilities to the employer. So, for example, if the shares are subject to PAYE, tax under PAYE when they're awarded, the employee is obviously going to have to pay that back to their employer. Since the shares aren't cash, the employee is probably going to be asked to agree to having the income tax deducted from their salary. Is that consideration? Is that just a sort of administrative requirement in terms of how the tax on the shares is managed? Again, it's not very clear. Similarly, a couple of things people might want to do: put performance considerations in agreement, a vesting schedule, ask employees, shareholders to enter into a shareholders agreement. All these things are things that would normally be quite routine for share awards, but because the employee shareholder legislation, as Stephen said, is not very clearly drafted, it's far from clear that they're actually acceptable. Another point: before the agreement becomes effective, there needs to be the employee needs to receive independent advice, and there needs to be a 7-day cooling off period. One point here is that often, because employees are often given growth share awards, the share rights can actually become very complex and difficult. We've certainly acted in relation to some employee shareholder share awards where, to be honest, it was quite difficult to explain the share rights to employees, and it took some time to brief the independent advisor. There's no specific statutory guidance or other guidance from HMRC setting out what the independent advisor should advise the employee on. It may just be the intended role. Certainly is probably just the independent advisor to say, here are the employment rights you're giving up, here's the value you're getting, are you really sure you want to do that? But in fact, actually advising on employee shareholder shares can be quite a complex task. There's tax consequences, there's legal consequences, there's employment rights consequences. It's actually quite rare to find a lawyer that advises on both employment law, corporate law and tax law. So generally the independent advice, certainly most lawyers are capable of doing it competently that we've encountered, but it's by no means a straightforward task. A minor point that actually as well, it does have to be a lawyer. It can't be an accountant or tax advisor, which sometimes surprises people. And you also need to make sure to provide for that 7 clear days cooling off period in your timetable when you're looking at the process for making the share awards. You certainly don't want to come into a situation where you've got your employee shareholder valuation agreed beforehand with HMRC. Maybe there's some sort of issue after that, getting everything sorted out, and you realise that you've got to go back to HMRC to get the valuation agreed again because you've forgotten to account for those 7 days. What are the requirements about the shares themselves? As I mentioned, they have to be newly issued. So you need to think about how that's going to be paid up, because the employee can't pay the nominal value of their shares, and the shares have to be fully paid up, and you can't issue shares for no consideration in a UK company. The shares can be in the employer company or the parent company, but can't be in another group company. So if you've got a company with 2 subsidiaries, the employees of one subsidiary can get shares in that subsidiary. They can get shares in the parent, but they can't get shares in one of the other subsidiaries. Because you can use shares in a subsidiary though, and this is the only tax advantage scheme where you can do that, then obviously this can be quite important and valuable to a company. And there's no specific trading requirement. There's nothing analogous to all the complicated EMI requirements you'll run into. It can be any employer company effectively. Minor point that there is one safeguard in that it's not available to employees with a 25% material interest in the company. I'm just going to pass over to Stephen again now to talk some more about the advantages and disadvantages of employee shareholder shares.
Okay, well, thank you very much, Charlotte. I think a lot of the advantages are fairly self-evident from the description we've given, but it's worth going through them to try and pull them together. So the first point is the one we've already referred to, that within the £50,000 initial value limit, the gains can be completely free of capital gains tax. Now, as I was implying when I was talking earlier, I'm not sure that the consequences of that have been fully thought through by the Treasury stroke HMRC stroke the government when the reliefs were being introduced, particularly as the shares can be restricted. They can be of a special class which reduces the initial AMV, actual market value, and it is possible to link the awards with growth shares. So to reiterate what I was saying earlier, what we talk about there is with detailed specific rights in the company's articles which limit the economic participation to participation in growth above a set threshold. This is a widely used type of structure, and there's been a recent survey published by HMRC which discusses the use of growth interests, not just growth shares, showing that they are widely used, showing the circumstances in which they're used, the potential commercial benefits, and that explicitly references the fact that growth shares can, in the right circumstances, be linked with ESS relief. So the shares can be in a subsidiary company. As Charlotte says, that's the only tax advantage scheme that I'm aware of where that is the case, other than in certain very limited circumstances. And this is of particular interest when you're looking at private equity backed companies. And my experience is that most of the arrangements that we've seen either are in PE backed companies or are in a company which has a similar philosophy to PE backed companies, looking for an exit, looking for circumstances where there could be potential for high growth in value, where the ESS relief is then linked to a growth share, and that then creates the scope for substantial value. I think the other practical point with that is that when you think about the concerns about the individuals who would be interested in participating in growth shares, giving up their employment rights, the reality is that the statutory employment rights will be of less significance for senior executives, highly paid individuals with probably valuable protection under their contractual rights which will survive any changes to their statutory provisions. That all fits together with the use that we've seen of ESS as being targeted more at a form of executive incentive than aimed at bringing in, for want of a better phrase, shop floor workers to facilitate startup companies. So I think that that's consistent with what I was saying earlier about ESS not being used necessarily in the way envisaged by HMRC. The shares can be offered on a discretionary basis. There's no requirement for shares to be offered to everybody, and invariably where this has been applied, that's been the case. It's not been an all-employee type scheme. It's not been tried to be applied in that way. The HMRC SAV, Shares and Assets Valuation Division, will agree values in advance, and this is one of the key benefits of having the ESS relief. With many schemes, most schemes in fact, it's not possible to agree values in advance. If you're having a normal growth share arrangement outside of an ESS structure, one of the difficulties with the implementation is that the advice which has to be given is that we think that the value is whatever we think it is, but we can't be sure. We don't know that the revenue will accept that, and therefore this is a potentially large advantage. In addition, the revenue in practice have accepted that what I've described there as a £2,000 underpin is sufficient. What I mean by that is that if the share rights contain a provision, the effect of which is that the individual has the right at any time to realise the value by way of a put option either back to the company or to a shareholder, and assuming that the counterparty is good for that money, that does mean that the shares will have a value of £2,000 irrespective of any other rights in relation to the shares and the value of potential growth. I've referred in the final bullet point there to offering for £3,000. The point with that is that in my description of the £2,000 underpin, I made the point about it being available at any time, and commercially that's often unattractive. People would prefer not to have that put right there sort of indefinitely, and one way of dealing with that, the concern being that if you have it for a limited period then the value of the put right may not be £2,000, is to have it for a slightly higher amount. So that's why we said a possibility there of having it as a right to sell for £3,000, but for a limited time only. Now equally, we're talking about disadvantages of ESS. The first is the obvious point from the point of view of the individual, that the statutory employment rights are being foregone. We've put in brackets there, but they can be reinstated under contract. Now the issue with that, the commercial issue with that, is that that's fine, but it may be more difficult for the individual to enforce contractual rights. There are going to be difficulties or potential difficulties with demonstrating loss in a way which is not the case with statutory rights. So contractual rights are not as good as statutory rights, but nevertheless they can be reinstated. There was some debate about whether this was acceptable when the ESS was first introduced. I know that some advisors have taken the view that it would be unduly aggressive to reinstate statutory rights by way of contract. I don't think that's the case. I can understand why that is said, but there's recognition in some of the HMRC publications that this could happen. And when I say could happen, I'm not implying a suggestion that it would be inappropriate. It's just recognised that the requirement of the legislation is that statutory rights are foregone, and that doesn't affect contractual rights and doesn't stop you adding back into the contract an equivalent to the statutory rights surrendered. Unlike, for instance, EMI, there is an upfront tax charge on any value in excess of £2,000, but the first £2,000 is tax-free, and the value can be agreed in advance, and therefore the tax will be known. And when we're looking at growth shares, the challenge is often to get the value up to £2,000 rather than to have issues with it being substantially in excess of that level. There's a lower limit for the CGT relief in that for the ESS the starting point is shares with a value of up to £50,000 compared with £250,000 for EMI. I haven't really seen that as a concern with the schemes that we've dealt with. I think because of the fact that they tend to be linked in with growth shares with substantial potential growth value. The employee cannot give any consideration for the shares other than giving up their employment rights, and there's a question which Charlotte's addressed already, well, what is consideration? And this is one of those areas where I don't think the drafting is as clear as it could be. I have concerns that in future years there may be differences of opinion with HMRC as to what that actually means and what is consideration. Another area where the legislation has not been very well considered in terms of its interaction with other areas of legislation is in relation to company law. And it's a requirement that the ESS shares must be fully paid, and the question then is, well, who pays the par value? And there are various ways of dealing with that. One way is to have a third party pay up. Another way is to have the surrender of the statutory employment rights treated as the consideration for the shares. It's an issue which can be addressed, but it does need to be addressed and is a trap for the unwary. So again, that's a potential problem area, needs to be identified, dealt with up front. The shares must be newly issued. We've put in brackets what we believe is the correct position statutorily, that is that the cannot use existing shares, cannot use shares held in an ESOT. However, there's BIS guidance from the government saying that existing shares can be used, and HMRC have said they will not challenge this, but that is not what the legislation says. And I think that the statements from HMRC are made in a way which means that the government and Treasury HMRC will be bound by those going forward, but it's not satisfactory to have to rely on guidance rather than the strict wording of the legislation. A key point and a risk area is in relation to ESS and reorganisations. The general rule is that on a reorganisation of share capital, the new shareholding is sorry, my screen has just played up on me. On a reorganisation of share capital, the new shareholding is treated as identical to the original shareholding for capital gains tax purposes. Basic tax rules. It's a section 127 of the TCGA, Taxation of Capital Gains Act. What that does in effect is to ensure that you do not have a tax charge when that happens. For ESS shares, however, this does not apply, and the result is that a reorganisation is treated as a disposal of the original holding, and that creates a potential trap. What that means is that the CGT exemption will cease to apply from the date of a reorganisation. So if you introduce ESS, you then have a reorganisation, subject to all of the other conditions being satisfied. That won't give rise to an immediate tax charge, but it will mean that the future gain arising after the reorganisation will not be protected from tax. So it's important to think about what a reorganisation is when considering restructuring of a company. It could include, for example, an exchange of shares for shares. It could include an issue of bonus shares, rights issues, schemes of arrangement, potentially even a variation of share rights, and this is where we get into an arcane area, potentially even if this has no economic effect. We're not proposing to put forward any definitive answers to those questions. The point that we're trying to make is first that the issue should be identified when the ESS shares are being introduced, so that the company is aware of that and it's there on everybody's agenda before any reorganisation happens. And the second point is that when a reorganisation is proposed where ESS shares have been issued, it's an important issue which needs to be addressed at an early stage in that process. Referred there to tax relief on the sale back to the company, and the point here is that there's a sale back to the issuing company is exempt from dividend treatment even if the shares are not held for 5 years. Normally, where shares are sold back to the company within 5 years, that results in an income tax treatment. It's treated as if it were a form of dividend where the shares have not been held for 5 years, and that's a problem in many areas of employee share scheme structuring and planning. It's not a problem here because we have a relief which stops that happening, but that's only the case if the shares are sold after the employee is no longer a director or employee of that or any associated company. So a point of warning there, again, on a sale back by a continuing employee, can be taxed as dividend income, would be taxed as dividend income if the shares are not held for 5 years, and the etc. there refers to all of the other conditions which need to be satisfied under the general legislation in order to be able to access the capital gains tax rather than dividend tax treatment. You can see there that there are a number of potentially complex issues, and I think that an overriding concern that I have with the legislation and its operation is this complexity. I think that there is scope for things to go wrong as time goes by, and for there to be issues arising with HMRC, particularly if, as I was alluding to earlier, over time HMRC, perhaps because of substantial gains being realised on a tax-protected basis, decide to scrutinise arrangements more carefully, and therefore I think it's important that advisors in particular are up to speed on these issues, that they communicate that to companies effectively, and that there's just thought given to how things might change over time. To some extent we're seeing that with valuation, and I've referred already to the ability to agree the value of share awards with HMRC before the awards are made, and in this context, particularly where we're dealing with complex growth rights, that is, I think, one of the big advantages of having ESS arrangements. The awards are often made over growth shares with complex participation rights, and that may be quite difficult to value. When you look at an ordinary share in the company, that has its own difficulties. Whole books have been written on the subject. Whole tax cases have been devoted to trying to work out what the legislation means in particular contexts. But whatever the complexity is can be multiplied when we're looking at growth shares. Superficially, you would say that a growth share has very little value because of the nature of sharing in future value growth only. But what we've seen is that the revenue have become more reluctant to accept, without detailed consideration, that a right to future growth has no or a nominal current value. The revenue have for some time required the provision of forecasts and details of the expected value if conditions and targets are going to be met, and that itself is an area for debate and discussion whether the revenue are entitled to do that. The practicality is that they do, and that if the client, or rather the company, declines to provide such forecasts, the revenue can decline to provide the valuation which is being sought. And there are then debates as to what forecasts and how reliable they are, etc. The key underlying point, though, is what the revenue are now doing, and I have some sympathy with the approach, is to say we don't just look at the shares today, we don't just take a snapshot of the shares today and say that they only participate in future value, therefore there is very low value. What they are becoming much more inclined to do is to look forward, think about the expected value, the expected payout from the shares over time, and then take that expected value, use that number as the basis for the valuation, and then discount back for risk factors, for minority holdings, for the fact that it does require growth, and will that growth be achieved. There's a whole load of factors which will push the value quite possibly all the way back to where you started, in terms of saying that the value should not be more than the basic £2,000. But there is much more depth in the analysis, and therefore a requirement for more details and a more considered approach when going to the revenue to explain why the shares are worth what you expect them to be worth, and to be prepared to justify that and explain it to HMRC in order to get the valuations agreed. So what that means is that there's a greater focus on the anticipated exit values, and then discounting those values back for the risk of non-achievement. It means that the approach is likely to lead to more challenging negotiations and potentially higher values, and as I've already said, places a much greater emphasis on a carefully considered initial valuation report and the need to allow time to negotiate values prior to the issue of shares. So just to focus on that, the final bullet point a bit more, that there are two clear and distinguishable points there. The first is that when putting in the valuation, a significant degree of care and thought needs to be given to why the shares are worth what the company thinks they're worth. And to put that another way, are worth as little as what the company thinks they're worth, because the revenue will be typically looking to argue that they have a higher value. And the second and related point to that is that if you wish to have the benefit of the valuation being agreed up front, you need to allow time for that to happen. HMRC are not going to react kindly to a valuation report coming in on a Monday afternoon saying, oh, haven't quite got round to giving this to you yet, but we're going to issue the shares on Friday, so will you please drop everything else and deal with it? The answer to that will be no. So it will be important to factor that in at an early stage and to give the revenue enough time to consider the valuation process properly. I hope that has given you some more insight into ESS. We've certainly been learning over the past year or so some of the issues that we've highlighted on the slides. I think there are points continuing to come out. The ESS will be a valuable relief for so long as it continues. How long that will be remains to be seen. But hopefully that has given you that more insight. If you want any more information, do please contact us. You should have on your screen now the details for all the partners and Charlotte in terms of email address and phone numbers. So if you do have any questions, do please feel free to email and we will respond accordingly. So thank you very much for attending. We do have more webinars planned, and we will send through details of those in due course. Thank you very much. Enjoy your day.
Thanks, everyone.